And welcome back. A short moment ago, we began a conversation with Professor Amanda Gouws from the South African Research Chair Initiative in Gender Politics, as well as Dumisani Rebombo from Sonke Gender Justice, with a focus on sexual harassment in the workplace following the country's fixation on the ongoing harassment hearing in the case of Andiswa Mengo and Judge President Selby Mbenenge. Prof. Gouws, before we went to the break there, and while we had that difficulty there, the question I'd asked you was, given the complexity of the evidence that the panel has to consider there, where it comes across in evidence and evidence in chief and cross-examination in chief, that Andiswa Mengo may have participated and reciprocated the alleged advances of Judge President Selby. She says she did so out of fear. She was scared of retribution. And oftentimes, this is exactly how sexual harassment cases play out, where a panel or an adjudicator has to ask themselves, was this consensual participation on the one hand, or was it submission? And of course, we know submission can never be consent on the other hand. What level of critical consideration should be given to that complexity as it plays out? Prof. Gouws, can you just unmute yourself? Sorry, we can't seem to hear you. Can you hear me now? Barely can make out what you're saying, Prof. Let's see if we can fix that. Dumisani, I want you to give a consideration to that conversation as well, to that question rather. Participation versus submission. It's a difficult consideration where the evidence isn't always clear-cut. Talk to us about how you're reading into that.
Sure. So for us, the whole issue of the legal definitions should not be left alone, because I think South Africa is seeing the big plateau of the power imbalances, where defense obviously would be skewed to saying, Andiswa is bringing selective, accusations, therefore, in a way, blaming the victim. And for us, we are concerned about that, because it's more like assassination of the nuances of her character in the submissions, instead of looking at the behavior of the judge.
And that the part of that difficulty is that it's one piece of evidence against the other, where sometimes there seem to be contradiction in versions of what may have happened. And again, when there's a dispute of evidence, the context needs to be taken into consideration, especially the context of power dynamics. Talk to us about how that often plays out.
Well, look, this is the highest office in terms of our judiciary, where we expect to see fairness and equity there. And we're talking about the second most senior judge in the country. So the whole issue where even the judge himself is the one who filed, the criminal case against the complainant, or the victim rather, shows how the one who's more learned with the legal fraternity, who's supposed to protect the workplace against such, is the one who's even using the systematic, which looks like systematic power over the victim for us.
Yeah. Do you at all think it's a good thing that this hearing is playing out so publicly, where oftentimes the incredibly difficult, robust, and some may even say invasive and vexatious cross-examination of Andiswa Mengo may itself be a inflection point that discourages other victims from coming forward on similar allegations, charges, and complaints? Do you think it's a good thing that we're watching this play out publicly?
Yeah, first of all, we commend even the bravery of Andiswa here, because it's very difficult for women to come out and speak against these types of atrocity or gender-based violence or sexual harassment in the workplaces. So I think the case is helping South Africa to introspect broadly and around this issue. So for me, it's very critical that, yes, there's a public viewing of the discourse.
Yeah. Without, of course, any presumption of guilt or innocence on the one hand, do you think that this hearing is playing out in a fair way that takes the sensitivities and complexities of victims into consideration?
No, we don't think so. We don't think there's fairness in that. We think the legal hat is the one that is dominant, and hence we understand obviously that social scientists would not agree on most issues sometimes with the legal fraternity. But I think in terms of fairness and equity, no, I don't think we have that. Look, in the history of the JSC, pardon me, for 10 years, this is the first time that when such allegations were brought up, as much as it is still allegations, the judge was not suspended. So for us, that's just something that is despicable.
Yeah. Prof. Gouws, hopefully we can hear each other, you and I, loud and clear this time around. Do you think that legal adjudicators have the necessary depth of concepts and instruments to be able to adjudicate the complexities of power dynamics and questions around participation, consent, and submission?
Well, can I just go back to say that I think we shouldn't underestimate the problem of power relationships here, right? She is in a position that he is her line manager. And whether she went along or not, women often go along because they fear that there will be reprisals, they fear victimization, and then along the line they realize it's not going to get better. So the issue here is, this is not the first time this president is accused of sexual harassment. It's an open secret. He has never been suspended. There was never any hearing into his behavior. And the question here is why the other male judges or male lawyers and advocates in that court did nothing. She asked for a mediation session with all of them, and she did not get it. So we have to understand that there is also men are complicit in this behavior of this judge president. He's gotten away with it for a long time. Now, in terms of do they have the necessary skills? Every organization have to have a sexual harassment policy. This is demanded by labor law. So what is the sexual harassment policy of this court, and what is the grievance procedure? And I think this is what we need to talk about, is why is there no procedure instituted? We know that there's so much secondary victimization going on, right? We saw this in the questions that's being asked of her by the defense, of course. And this is, they have to make her untrustworthy, discredit her witness, and so on, because that's the only way they can get the judge president off the hook. We've seen this in the Kwesi case with the Jacob Zuma rape trial. So we need skilled people. And these are people who are skilled in dealing with sexual harassment cases, skilled in asking the right questions, skilled in also protecting the witness from secondary victimization. And
what does that look like, Prof. Gouws? I perhaps want to touch on what you brought up, the Kwesi case in the Jacob Zuma rape case. There we heard Kwesi being asked questions like, what were you wearing? Why was your body language so suggestive? And what analysts had told us after the fact of that case is that those questions were re-traumatizing, deeply inappropriate, and a form of secondary victimization. How has some of those nuances of secondary victimization played itself out here? And what level of protection would you have liked to see the chairperson of the hearing and the panel perhaps extend to the complainant in this instance?
Right, so we call those questions about what were you wearing and so on, rape myths, right? So what needs to be done is she is not the one on trial, but she's treated as the one on trial. So, some questions just need to be ruled out of order. And I think, there is a reliving of this trauma because, now she's asking about the pictures that he sent her, and her own complicity in maybe going along with it. And that is why you also very often don't have the complainant and the perpetrator in the same room in order to prevent that type of victimization. But it is really, I mean, I think she's very brave, and I think it's really difficult for her.
Do you have
And I mean, this is the problem for people coming forward, and this is why many women just don't come forward.
Yeah, just on that, on the pictures that were alleged to have been shared, and of course, without presuming guilt or innocence on any party here, part of the questions are, did the pictures you alleged to have been sent, do they actually exist, and have they ever existed? Because there's seemingly no evidence to the allegation that you're making. That was one of the questions put forward to Andiswa Mengo by Advocate Moses Kakane over there. That is an important evidentiary question, and a lot of this trial will turn on that question, because it's not only a question of credibility, but also a question of establishing fact. Do you think that the approach in terms of the framing of that had been the correct one?
Well, you know, there's argument that things on both sides were deleted. But no, I don't think that is the right framing. The framing should be why there's been this type of behavior in the first place. When she spoke to a colleague, and she didn't mention names, the colleague asked her, did you get these pictures from Judge Mnenge? And she said, yes. And she said, well, he's well known for that. So there is at least a hearsay record that he is involved in this type of behavior. But I mean, this is always the problem with rape, is that they very seldom leave witnesses, and it's he said, she said. And we're going here for this whole situation where she's going to be discredited. Why is it the case that the judge is not answering for himself on what he has
in fairness to
her?
in fairness to the process, Prof. Gouws, he's yet to take the stand and also answer these questions as well. I mean, that is just a matter of procedure. But thank you so much for your time and your insights. I really do appreciate it. Dumisani, Rebombo, thank you so much for your time and your insights as well.